Is Mr. Burbank, Mr. Smith, the sentencing on Augustus Simon? I'm sorry? Okay, we'll hold it for just... How many witnesses are you going to have? Okay. I don't know if I knew that exactly, but that's okay. We'll take care of it. Mr. Burbank.
Especially set for 11 o'clock.
Something else is at 11. Yeah, something else is at 11. But that's okay. We'll make it work. Do you have other courts that you need to be in, Mr. Burbank?
I've got a passport to be in a foreign country at 10 o'clock.
Already you can feel the courtroom juggling act, witnesses missing, schedules clashing, and a lawyer casually mentioning he's got a passport out of the country. Court isn't always order, sometimes it's organized chaos. Ever wonder how judges keep calm through this?
No, I don't know.
I've got a big document.
Oh.
I've got a big document.
Okay, if you can contact and make sure whoever's coming is on their way so we can get it taken care of, since it was set at 9 and Mr. Burbank's here.
Your Honor, if I may, I think there's some emails that came over this morning in reference to my client from some family members that came in about 6 o'clock last night.
Okay, did you send those to Ms. Holmes?
I'm supposed
Okay.
to forward them to them.
Okay, I'll take a look at them in just a minute as well. See, Mr. Parker, are you ready on Devonta Anderson as the sentencing?
I want to.
Sure, yes, sir. What about Dedrick Davis, Mr. Parker?
I think they're fingerprinting.
Okay, I'll hold that. And Alvin Lewis?
They're I think they're. I need to go tell them. I need to go relay a message to the prosecutor. We thought when the case was dismissed, so
I'll hold that. And then Almeda Miles is your last one.
I've signed her up.
Okay, as soon as all those come through. And I'll go and let you talk to him about that, and I'll get you all taken care of in a minute.
Thank you.
All right, you can let them read that one if you want. Mr. LeBlanc, do you need a minute on Linton Arsenault? Well, morning, Mr. Hoffman.
Morning.
All right, sir, you're Linton Arsenault, and Mr. Arsenault is charged with failure to comply with sex offender registration requirements. We've gone over before with, yeah, I think that was maybe with Mr. Lewis before you were appointed, and what the offer was and rejection, and what's the status?
The state's not gonna go any lower, Judge. That's the only offer, and it's gone today. So he can take it today, or you can go to trial.
Okay, thank you, Mr. Hoffpower. Mr. LeBlanc?
Yeah, I conveyed that to him, we discussed it. That's my understanding.
You want to go to trial? Okay, so I just want to make sure, and we've gone over this before, you understand if you go to trial.
This is big. The judge spells it out crystal clear: reject the plea deal and risk 25 years as a habitual offender. That's the brutal math of plea bargains. Take less time now, or gamble with your future. What would you choose?
And you're found guilty, and those prior convictions are true, that you would be considered a habitual offender, and your minimum punishment would be 25 years, you understand? And it looks like that offer that was made is for going on count one only for a 10-year term in prison. Again, you've got every right to reject that and go to trial. Just want to make sure you understand possible consequences, options, and all of that. All right, then we'll get it set for trial, and Mr. LeBlanc will begin preparation for trial. See, it's Mr. Smith. Okay. I just want to get that started no later than in 5 minutes so that Mr. Burbank, we can get him, he's got to go to another county. So if you want to let him know, I'm ready to get it. Oh, there you are. Are you ready to go ahead and get started?
So you've got some here, I'll just make sure that
Okay, is she here?
somebody can just write it.
Okay, I want to get started in 5 minutes, please. Charlie's. Mr. Rojas, let's see. You have Lawrence Jackson?
Yes, ma'am, we just,
Okay, let's see. Janisha Leonard, Mr. Coleman, and Mr. Rojas. Did you have that printed out? That's fine. I'll pull this up here. Good morning. You had that other stuff that he did printed out for me. Did you bring it? Did I keep it on my desk? Janisha Leonard. Okay, while they're getting her, let's Ridley McKinney. Y'all got something you worked out, Mr. LeBlanc?
Yes.
Okay, so don't get rid of that one off the docket yet. Good morning. Are you Ridley McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3.
We do, but we're not gonna go for, trial allegations.
Okay, state's gonna abandon one. Will he waive the formal reading of that motion?
He will,
I just asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your community supervision. Shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes.
It alleges in count 2 that you were at a location other than that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's good.
Because it was refused by our office.
Okay.
And the like witnesses, it's the same. This one, but therefore we refused. I'm not gonna go forward with the allegation.
Okay. So there a no contact order in the probation though?
They're married.
They're married, Judge, and it's, I know the optics of it is bad for the kind of offenses he's on probation for.
Y'all hold it down just a little bit. Go speak.
So it looks bad for the kind of probation, case that he's on probation for, but the complaining witness has come to my office, I've spoken with her.
We followed up with Judge if we had it to move forward.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation and order 60-day jail sanction, and it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. McKinley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as it's required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or be in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. Did they get, Miss Leonard? Y'all have Miss Leonard? Come on up, Miss Leonard. Janisha Leonard, 3 cases are called. All right, you're Janisha Leonard. And Miss Leonard, in cause numbers 19-333, 40 and 20-36095 on probation for theft of property and theft of service, and a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property, and so that theft new allegation is from offense date of August of 2023, and so obviously that was some time ago. There's a motion, let me get to the right paperwork, in each of these cases obviously alleging that new offense. Mr. Rojas has filed motion in each of those motion to revoke probation cases that I set a bond, that currently they do not have a bond. Those are deferred, correct? Are they both deferred? Let me double check.
I think they're straight probation.
They're straight probations?
They
Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward. Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
And Ms. Leonard, how long have you been in jail now? And it's my understanding that you've got a newborn baby at home. How was that, child?
This moment stings. A young mother, locked up, trying to explain how jail time is affecting her newborn's health. It's a rare glimpse of how legal decisions ripple far beyond the defendant. Should compassion outweigh the strict letter of probation rules here?
And there's a little, you're having, or before you come in, you're having issues with breastfeeding or breastfeeding child.
Yes, ma'am.
Tell the judge about that.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to a bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense, and then there is some community service hours, and then very behind in fees and fines. Other than those things, I've got probation here, and if you'll just state your name for the record, ma'am. And is there, other than those items, is there any other issues that you are having with Ms. Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and doesn't, for this purpose, I guess doesn't really matter. But because it's been so long, and it looks like other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. I'm going to set the bonds in each of those cases at $5,000 in each case. And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included in the $10,000 bond charge?
You have 3 different bonds. You've got a $10,000 and 2 $5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You can still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay? All right, we'll see y'all back at an announcement. We'll worry about that later. Yeah, I can't imagine that's going to be. Okay, don't need that. That's all right. Got it. Hallie Rolls, Mr. Rojas. And then we'll take a break, and I'm going to have to do a hearing with Mr. Burbank. Mr. Burbank, I'll take care of your case next. We'll get started as soon as I'm done with this. For both or one?
One's a motion or vote.
Oh, okay. This is.
Did I put the wrong number on?
No, you just didn't finish. That's all right. Okay, so let me go. Are you Hallie Rawls? Will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Ms. Rawls, in cause number 25 DCCR 0623, let me pull the wrong one. You're charged with the third-degree felony offense of possession of a controlled substance from May 30th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Rawls is not competent?
No, Your Honor.
All right, ma'am, in cause number 25 0623, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 241987, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation January 27th, 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 13th, 20th, March 6th, 20th, and April 8th of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not provide verification of performing the community service as required. Is that true or not true? Count 4 alleges that you did not provide verification of completing the theft prevention class. Is that true or not true? Count 5 alleges you're behind in your court-assessed fees. Is that true or not true? And then count 6 alleges that you failed to complete a mental health evaluation. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have some documents in that case here on the computer that have your signature on them that the state's marked as exhibit number 1. Did you also sign and go over these with Mr. Rojas? And do you fully understand them? State tenders number 1.
No objection.
It's admitted. I'm going to find, Ms. Rawls, that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find that those counts true, again, that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These sentences will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. That's okay. I caught him.
It's a good catch.
Quick reflexes. Hold on just a second. What do you need, Mr. Samuel?
Hearing, this is a quick motion on, expert, as well as to set bond. I have 10 o'clock dinner.
Okay, Mr. Burbank's supposed to be in. Okay,
Yes,
okay.
you don't want
Cody Dent. And this is a bond hearing on the 2 MTRPs.
Yes, I've got 4 too. I guess we'll just do it after Burbank's hearing, but I've got 4 that are in custody that
Everybody here's got all the things this morning.
I can wait, because they just may want to hear.
Everybody's in jail today, so thank you. And you've got something at 11 also, so you got a hearing at 11, so we're gonna take care of some other things since you've got that anyway. If you've got anything to sign up or work on, you can get that taken care of before. All right, are you Cody Dent?
Yes, ma'am.
And Mr. Dent has 2 motion to revoke probations in cause numbers 13-17772 and 22-41052. And there's a new offense, a burglary of a building, in cause number 250807. Mr. Samuel has filed a motion asking that I set a bond in those 2 MTRP cases. Is that correct?
Yes, Your Honor.
Let me get that pulled up.
As well as the motion for access to legal expert.
That I probably don't even need to have a hearing. If you've filed the motion and there's,
Yes.
I'll look at it if you'll just get it all filed with that attached to it. It needs to be e-filed. I'll take a look at it. It's no problem typically, as long as you have that affidavit of indigence attached. Okay, so. Oh, here it is. So are there no bonds set at the time?
Correct.
Okay, and are they deferred?
Yes.
They are both deferred. Mr. Smith, what is the state's position with regard to bonds?
I show one, 22, 105, so it's a straight motion, 2 years, suspended for 5 years.
Which one?
The second one, which would make sense if he got on probation after he was already on probation. Give me just a second. I want to take a look at the PC and that new offense, and then I'll let you put on any testimony you need. All right, I'm printing something. Do you wish to call a witness, Mr. Samuel?
Yes. Oh, Mr. Dent.
And you need to speak up so the court reporter can hear, please.
Mr. Dent.
Mr. Dent, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. Go ahead, Mr. Samuel.
Yes, Mr. Dent, you were placed on probation initially in 2015, is that correct?
Yes, sir.
Okay, and since that time, you had one other charge that came up, is that correct?
Yes, sir.
Right now, are you presently under the care of any doctor facility?
It's been a time.
And are you presently on the medications at this time?
Yes, sir.
Okay, and what medications are you on?
Ooh. Don't make me lie. I don't know them by heart.
Okay, you live with, who do you live with?
My grandmother.
And you don't have any children, is that correct?
No, sir.
And your only source of income is from SSI?
Yes, sir.
Okay, and with that, now, going to the date in which you were last arrested, that was, when it says burglary of a building, that was a container, is that correct, at a business?
Yeah, well, I thought it was a Gibson dumpster.
Okay, I'm just answer the question that I asked you. Okay, it appeared to be a dumpster, is that correct?
Yes, sir.
You didn't think that was anything wrong with getting something out? You thought it was trash, is that correct?
Yes, sir.
Okay. At that time, had you had your medications?
No, I didn't take it anyway.
Your Honor, we believe that, man, I passed the witness, Your Honor.
Any questions with regard to this hearing?
No question.
All right, give me a second. I'm reading the pre-sentence report, the PC. So it shows that the allegation is from theft at Discount Tire.
Right,
And there was a shipping container.
right.
And he was allegedly removing tires and placing them in his vehicle.
And here's the clash. Dent insists he thought the tires were trash, but the state sees burglary. Add in his shaky mental health and 2 active probations, and you've got a legal and moral puzzle. Should intent matter more than the letter of the law in cases like this?
Right.
And this the business apparently was closed, signs on the container.
And when we show the container, the signs, they somewhat obscure, but they were there.
But they're on the business
Right.
property with tires that belong to Discount Tire business.
Used, and the value of the tires were
Doesn't
$50 a piece. I
Okay.
understand.
I guess I just want to make sure the problem is if we're having, okay. So the first probation was for obstruction or retaliation placed on that probation in 2015
Correct.
for 5 years. I'm assuming that has been extended. And then while on that probation, there was a theft of property, was continued on the first probation, placed on probation in February of 2023 for a 5-year straight probation. And now we've got this.
Correct.
Okay, I think at this time, based on the nature of the underlying offenses and based on the allegation in the new offense, based on the fact that there are some obvious mental issues, I don't know that it's in the best interest of anyone for me to let Mr. Dent back out to be doing the same thing. It sounds like he's stabilized. I want to make sure he is. We can get an evaluation done. We'll get you an expert, and then we'll set it for a hearing. But I'm not going to grant the motion setting a bond. I don't think that is in the best interest of our community or Mr. Dent for that matter.
Why can I, excuse me, can I ask you something, Ms. West? Why can I not get a bond?
Because you're on 2 felony probations, and the allegation is that you committed another felony offense.
I don't think there was a crime, taking some tires, getting some tires out of the
Well, then that's a bigger problem. All right, you can go back with the bailiff.
I don't see that you filed